Tom, I think you're first, so I'll hand over to you.
Fabulous, thank you. So you might need to do my slide shuffling if that's all right.
Of course it is. I exist to serve.
Brilliant. Okie dokie. Well, perhaps the most sensible place to start, I would say that because it is where we are starting, is Regulation 15 of the 2018 version, the new version of the package travel regulations. Package travel, link travel, arrangements, regulations. I always find that double plural a bit difficult to get my tongue around. So as we all no doubt know, the second paragraph of the regulation, Regulation 15, provides that our package holiday organizer is liable to the traveller for performance of the travel services included in the package travel contract, regardless of who is actually providing that service, i.e. whether or not it's them or the hotel or a different legal entity in or any other legal entity. Given the way in which package holidays are actually put together, with in most cases hotels being these entirely distinct entities from organisers, not in all cases, but in a lot of cases entirely who aren't being controlled in any way, sense, or form by the organiser. This regulation is an odd provision, to put it bluntly, and one which sits at odds really with the traditional common law approach to the law of contract, with things like freedom of contract, agency, privity, and so on. It's odd because the organizer doesn't have that control over the hotel in most cases. And so why should the organizer be warranting for the performance of that hotel? So it's not, it clashes with the kind of classic English contract law position, but that's because, of course, as we all know, this is part of the EU consumer protection project. This all comes out of the package travel directive on the EU side. So it clashes a little bit with a classic English approach, but it is much more of a kind of European consumer-friendly, consumer protection type approach. More of that later when we get on to airlines and unfair terms. So what does Regulation 15 do? Well, as we all know, it expands contractual liability. Creates this kind of liability of, in all cases, I should say, entirely separate legal entity for whom normally it wouldn't have any kind of vicarious liability or wouldn't be making contractual warranties for. So that's what Regulation 15 does. If we can move on a slide. Yeah, so this slide develops what I've been talking about, this unusual nature of this contractual liability. It's clear from this definition of the word organizer. Regulation 2 of the 2018 regulations does all of our interpretation, and this organizer definition is taken from that. It's clear how wide the scope is and how distant it is from that traditional form of an agency relationship or a master-servant relationship, or even a subcontractor situation where there's a primary contract and then services within that contract are subcontracted out to different suppliers, where in traditional English contract you might see the kinds of warranties on performance that could be expected there. Here, an organizer is very, very broadly defined. First in A as perhaps something which is closer to an ordinary definition of the word organizer of a package holiday, a trader who combines and sells or offers for sale packages either directly or through another, or together with another. So someone who actually organizes that package holiday. But also B, in these new regulations, in the 2018 regulations, the organizer is someone who passes on the data of the traveller for a separate contract to be concluded with another travel service provider within 24 hours. That's not on the slide, but that's part of the interpretation section. I think it's Regulation 2, paragraph 5, and the definition of the package there, which is referred to as by the definition of the organizer. But someone who passes on the data, email address, name, etc., to a different trader, and a different contract is concluded with them, provided it's all done within 24 hours. So this definition of organizer really distances, as I suppose, the function that the organizer is performing from what that organizer is actually warranting to do under the contract. You know, why policy-wise should it be that somebody who simply concludes one part of a contract and then sends the data on to someone else to conclude a wholly separate contract? Why, as a matter of that person should be liable for the obligations of anyone else under the separate contract is quite surprising, but of course it comes from that place of EU consumer protection, and it gives that consumer an easy way of claiming where something goes wrong. Next slide then. Okay, so that's the preamble. What we've just had is a preamble on how those regulations work and how slightly at odds with the English position they are. Obviously now, post-Brexit, maybe they'll end up on Jacob Rees-Mogg's bonfire as sort of EU-derived law, which clashes with the traditional English position, but probably not, because it's consumer-friendly, and generally speaking, politicians don't really want to change things that are consumer friendly. So let's have a look at what contractual terms there might be within the holiday contract which an organizer might pick up the liability for. The list here on this slide, we've got written express terms, oral express terms, various heads of implied terms, statutory, business efficacy, officious bystander, etc. Sandwiched in the middle of the slide there, we've got a separate heading for the brochure. And that's because the operation of the regulations puts the brochure, the holiday brochure, in a slightly murky puddle of a category. Are they express terms? Are they representations? Are they advertising puff? What is the brochure doing? And I'll talk about that more in just a moment. Next slide, perfect. So first of all, written express terms. So putting aside that brochure for now, these are the classic terms and conditions that are provided. Sarah referred to at the beginning, that very few people except for lawyers read, and are normally read after the event rather than before the event. Occasionally, organizers take on more obligations than they actually have to under the regulations in their written express terms, and they do make certain warranties. So it's always a good idea to go through what's set out in their T's and C's, and if there's anything there to attach onto that isn't otherwise something we'd get implied into via the regulations or via other methods of implication. If there are actually some express terms in there that claimants can rely on, if we're working for claimants, then we want to go through with a fine-tooth comb and see if there's anything express in there that we can latch our claim onto. That's from a claimant's perspective. It's more typical, probably, in my experience, for organisers to maybe attempt to exclude things which aren't actually able to be excluded. Certain exclusion clauses for liability, attempted waivers, etc., because of the way in which the regulations work and because of the way in which statute implies terms into these types of contracts. It's quite difficult for an organizer to be able to exclude well, it's more than difficult, it's impossible for the organizer to exclude some consumer protection provisions. Next slide.
Sorry, Tom, just to pause, if we can, we've had a question from Luke.
Oh, yeah.
Yeah, who asks, claimant books a package holiday, whilst at the hotel, claimant rents a pedal bike. The bikes are supplied to the hotel by a third-party company. The bike wheel falls off while C is riding it, causing her to break her foot. Would the claim be against the travel provider or the hotel? I think, in answering that, I know it's a question for you, but I'm going to answer it anyway. I think you need to look, Luke, at the previous slide. Sorry, Tom, I'm just going to go all the way back to 15.2 and just do the analysis on the organizer is liable to the traveller for the performance of the travel service included in the package travel contract. And the answer to the question is that's not a service that was included in the package travel contract. So if, for example, the traveller had pre-booked that excursion as part of the package travel contract or the linked travel service, you might be able to sue the organiser. If they haven't pre-booked it, it's not a travel service included in the package travel contract. It's just a local contract, which is going to mean that you would have to bring it against either the hotelier or the supplier, but locally, and the applicable law is going to be the local applicable law. You couldn't bring a claim against the tour operator. Tom, I don't know, sorry, I answered that rather rudely instead of you.
No, that's absolutely fine. No, I fully agree with that. There is that I was trying to play with in a case a while back. There is that slightly odd, let's pull it up, extra definition of a package, which includes bits that are added after conclusion of that package. Which one is it? Yes, it's Regulation 2, paragraph 5, subparagraph B, Roman numeral 4, services which are combined after the conclusion of a contract by which the trader entitles the traveller to choose among a selection of different types of travel services. Which is a slightly odd one, and I did a lot of hunting around when I was looking at this to see exactly what this meant, and it's referring to like gift box package holidays. I don't know if anyone's actually come across these, but essentially where you're given a gift box of a package holiday that allows you some choice later on about what travel services you get. So it might be, for instance, that you have a gift box package holiday which includes either a bike ride with the hotel or a dinner out at a fancy restaurant or a I don't know, kayaking adventure on the sea, or whatever it might be, and you select the bike ride at the hotel, but in a sense it was already one of the options that was provided to you at the point at which the package was purchased. Even though it hadn't been, it was an option for purchase as part of a gift box or selection of different options. So that might be one.
That's a really good point, actually. I always forget that provision. Somebody else saying, can we save the questions to the end? The answer is we never save the questions to the end, because if you save it to the end, you're never going to remember what you wanted to ask previously. But don't worry, we've got an eye on the time and you will hear the entire presentation within the hour. So don't be concerned about that, because unfair terms we can go through pretty quickly. Right, Tom, I'll stop disturbing you. Oral express terms.
Sorry, yes, I'll rattle through. So oral terms are a bit more tricky. Classic English position, of course, is that where an agreement between contracting parties has been reduced to writing, i.e. where you've got a written contract, it's very difficult to argue, if not impossible to argue, that the written contract doesn't actually contain the full agreement and that there are separate oral terms which aren't actually written down. very, very difficult to do. You might be able to argue some kind of a collateral oral contract which runs parallel, but then you've got to have separate consideration which passes between the parties in order to create that collateral oral contract, which might, it's quite tricky to imagine a situation in which that happens. I mean, I suppose if you have someone booking a package holiday, completing the booking of the package holiday at a high street retailer, and then shortly afterwards going, oh, actually, I just remembered that we need something else. I don't know, we need special accommodation on the ground floor or something. And they say, well, we can do that for you, but it will cost you a bit extra. And then they give a little bit of extra money, and then the agent says, okay, we'll sort that out for you. And then it doesn't get sorted out and something goes wrong. You might have an oral collateral contract there, because you might say, okay, well, we've got an oral agreement between the consumer and the agent that this would get sorted out. Consideration has passed in the form of an extra payment for the extra bit, and it's collateral to the package contract because the package contract has already actually been concluded, and it was only realized afterwards that an additional aspect needed to go in. It's a far-fetched scenario, and it's probably unlikely to eventuate in reality. More likely, when we're talking about oral terms, is we're not really about oral terms, which are contracts, representations which don't actually form terms of the contract, and therefore where things go wrong because of oral terms or oral representations, our action isn't for breach of contract because they're not terms of the contract. Our action is in misrepresentation under the 1967 Act. A representation has been given, which, let's say, is wrong in fact, it's been made carelessly, and it induces us to enter the contract. What might an example of that be? Well, putting aside a brochure for now, I'll talk about the brochure in a second. You might get representations made about the quality of the hotel, which do induce a consumer to make the choice of that hotel as part of choosing the elements of the package. For example, food hygiene would be a good example. You might have a consumer say to the retail agent, oh, this hotel looks good, but what's the food hygiene there like? The agent says, oh, yes, food hygiene is fabulous. They've never had any issues whatsoever. No problems at all. The contract is formed, the traveller goes, traveller gets salmonella, later discovers there's been a big outbreak and loads of complaints at the hotel. Well, that representation from the agent is probably careless as to the truth. It was wrong. There were problems. There were difficulties with food hygiene. There had been an outbreak. Did it induce the traveller to enter that contract? I mean, so if they say, well, we could either go for Hotel A or Hotel B, and a representation is made that Hotel A's food hygiene is really outstanding, then we could probably have an argument that the traveller was induced to enter the contract by the representation. It's going to be hard to evidence, though. That's what makes these kind of oral terms, oral representation type cases quite difficult to run, because it really relies on the credibility of the witness, and often that can only come out properly in cross-examination. As an aside, misrepresentation is often a way to generate a cause of action against a retailer who may not, in fact, be the supplier of a package holiday, or may not be the organizer, I should say, of a package holiday. If you had a situation where actually the holiday being offered wasn't a package, but the retailer nonetheless made a representation that food hygiene was outstanding, or whatever it might be, then you possibly action against the retailer, irrespective of not having a package, because a representation induced you to enter a contract. So that's that slide. Next slide. The brochure. Yes, well, the brochure is a bit of a murky one. Absent the regulations, the brochure unless it's expressly incorporated into the contract. In classical English contract law, it would not form part of the contract. If it's not written in, it's not part of that contract. Any written statements in the brochure wouldn't become contractual warranties. A claimant would be restricted to an action in misrepresentation, which I've already talked about. All the evidential issues I've talked about. Did something written in the brochure induce the claimant to enter that contract, and was the representation made in the brochure wrong? But the regulations do something a little bit odd here. That Regulation 6 tells us that, well, Regulation 5 tells us that an organizer absolutely must give written information about the package prior to the conclusion of the package contract. Regulation 6 tells us that written material which an organizer has to provide forms an integral part of the package travel contract. So an integral part, that in essence means that the written information becomes the written express terms of the contract. They are incorporated into the contract. Now, traversing Schedule 1, there's some terms of a contract: dates and times, number of nights of stay, means of transport, prices, locations, essentially quantitative stuff. And there's also standard kind of procedural contractual provisions on terminations and insurance, etc. That's all fairly standard. But there are some bits in Schedule 1 which might raise an eyebrow for someone not expecting these types of things to be express terms of a contract. For instance, paragraph 5, you have to tell the traveller the main features of the accommodation. The main features of the accommodation. Well, what does that main features mean? On the slide, there are a couple of examples. There's child friendly. Let's say a brochure is provided which sets out that a hotel will be child friendly. Is that a main feature of the hotel? Does it become information provided in accordance with Regulation 6? It's information provided before the hotel that sets out a feature of the hotel, child friendly. Is it a main one? Does it form a term of the contract? Difficult to say. Gym facilities is perhaps more obvious. Yes, gym facilities probably is a main feature of the hotel. If something goes wrong because there were no gym facilities, quite hard to see what that case would be. But if something goes wrong there, are there damages for breach of contract available? Outstanding cuisine. That sounds like traditional puff, but potentially could be a main feature of the accommodation. So it's brochures are quite an interesting one because they do create potentially express terms of the contract, which then can be relied on, where those things are main features of the accommodation provided. Next slide. Okay, implied terms. These are the statutory ones we're all extremely familiar with. The first bullet is a technical one. The fact that actually the cause of action under the regulations is not for breach of the regulations. It's because Regulation 15, paragraph 1 implies paragraph 2 into the package contract, the paragraph we spoke about right at the beginning. So it's by way of an implied term that one brings an action pursuant to the regulations, rather than, as it were, a breach of the regulations themselves. It's not a breach of statutory duty. It's a breach of an implied term of the contract. Sale of Goods Act and the Supplying Goods and Services Act, now, as we all know, unified in the Consumer Rights Act. these are the classic pleadings of claimants in holiday cases. We have the famous case of Wood and Toohey as the one discussing the rather philosophical question of the transfer and title of food. When does property and food move from one person to another? The applicability of the Sale of Goods Act, and then the contractual liability for goods of satisfactory quality. And that's what Wood and Toohey is really all about. As we all know, when food which is contaminated with a pathogen is provided by a hotel to a guest, it's very difficult to see how that could ever be thought of as of satisfactory quality. And so there's almost always, where proven, then a breach of an implied term of the contract without needing to resort to local standards, which is useful for claimants. Now, the Sale of Goods and Services Act covers services, of course, as well as goods, and provides that implied term parallel to negligence, services to be carried out with reasonable care and skill. And so providing goods of satisfactory quality, providing services with reasonable care and skill cover the vast majority of implied terms in our package holiday contracts, because they're very wide in scope and they can cover almost everything we can think of. But there might also be cause to rely on common law implication of terms under either the officious bystander test. That's the one where you say, of course, the parties meant to include, or it goes without saying that there would, which would cover such and such. Or the business as a business arrangement, unless the term is implied. So let's jump to the next slide, because I think that covers some of examples of these. Yes, I'm slightly short on time, so I won't come up with convoluted fact patterns to demonstrate the points, but there are going to be occasions where it could be integral to a cause of action to have some of these implied terms. We've got compliance with international standards. Reckless and dangerous driving is an obvious one. It's a clearly got to be an implied term of a contract that if driving is one of the services provided, it's not going to be reckless and dangerous. I mean, probably would be covered by the reasonable care and skill statutory implied term anyway. The last bullet there is a reference to one of Matt Chapman's cases, where the claimants were attacked by lions while on safari in Tanzania. It was really argued as a local standards point, but as I've sort of mentioned or referenced before with the food of satisfactory quality, an alternative way of looking at it is that you could have an implied term here. Is it so obvious, i.e. on an officious bystander point, is it so obvious that there should be a warranty in the contract that the safari camp in which these claimants were staying would be sufficiently protected from wild lions coming in and attacking them while they slept? Is it sufficiently obvious to go without saying that you don't actually need to have anything expressed in the contract because it can just be implied in? The normal approach, as we all know, is that claimants have to prove, always rigorously put to proof, on the local standards which apply. But where it seems so obvious that it might satisfy the officious bystander test, might we be able to get around by way of an implied term that safari camps will be kept reasonably safe overnight? Right, moving on. I'm aware my half hour is up, so I'm just gonna rattle through airlines.
That's okay, don't worry.
I think a lot of this can be covered quite quickly. As the slide says, contracts for carriage by air are often very technical. We've got the Montreal Convention, the international convention, to which the UK is obviously a party and which has been also implemented domestically in statute. We've got the EU denied boarding regulations, which are retained law following Brexit. So we still have those with the necessary changes being made, i.e. member state now changing to UK and member state. And then at the bottom, residual contractual liability catching everything underneath. Okay, so next slide, Montreal. The most important thing about the Montreal Convention to mention here when it comes to creating contracts is its exclusivity. If a claim falls under the Montreal Convention, there is no other cause of action. And this can be a pretty serious problem for limitation, which under Montreal is 2 years from the date of arrival, or the date where you should have arrived if you don't arrive. There is no possibility of extension. So it's one always to remember in these cases: 2 years, not 3 years, which is the classic UK position. And the point really about the convention is that it strikes that balance of interest between airlines and passengers. Because airlines can't contract out of it, then these limitations of liability, which are set out by the convention itself, operate, as it were, to try and balance it back out in favour, or not in favour, but balance it back out so no one is favoured towards the airlines again. So it's not as consumer friendly as some of the EU scheme, and that takes me neatly on to the denied boarding regulations. This, again, part of the EU consumer protection project, heavily weighs down in favour of consumers. It prevents airlines from contracting out. Compensation rerouting has to be paid in certain situations. From a legal point of view, interestingly, unlike the package travel regulations, the cause of action, as it were, is for breach of the regulations. It doesn't imply terms into the contract in the same way that the PTRs do. The regulations impose the obligations generally. They are predicated on a contractual relationship, but one's action for them is not, as it were, for breach of contract. These are the minimum set out for under the slide, and parties, of course, in the normal way are free to bargain over and above the minimum requirements. And so, again, in any contractual claims relating to air carriage, one always should look at the precise terms and conditions of the contract to see if there are other bits and bobs which wouldn't be covered either by Montreal or the TBRs. And in fact, that's really what the next slide says. If Montreal or the denial regulations are not in play, then it's standard, and we do the normal thing that we as lawyers do, which is look at the contract, look at the terms, look at what's going on, and work out what breaches there may be and what remedies there might be available. Having said that, although actual interpretation, the EU Consumer Protection Project still has a lot to say about it, because it is a consumer contract, and so all of the various directives and regulations on consumer protection come into play on things like fairness of terms. And at this point, I'll pass over to Sarah to take forward discussion of fairness of terms.
Thank you, Tom. Yeah, I mean, I think the message is that where you're looking at a holiday claim, either a package travel-based claim or an airline type claim, you need to look at the standard terms and conditions. It's quite surprising how often people don't have them or don't look at them. And I've seen cases where the terms and conditions have never been disclosed. And that seems to me to be odd, because it might create a cause of action, or it could, less likely, give rise to a springboard for a defence in a case. So it's always worth having them. Let me just answer a question from Darius, which is a variant on previous question. Claimant books a cruise, at the same time books the bike tour offered by the cruise company, but supplied by a third party. Cruise companies' booking conditions say that any such tours form a separate contract between the prospective passenger and the third party. Do the regulations allow that, or will the cruise company be in breach of the regs? Because, of course, if they're in breach of the regs, so if they're trying to do something that isn't allowed by the regs, then that part of the contract will be struck down. The answer to that is that it depends precisely what's going on and how it's going on. But if you book the excursion at the same time as you book other travel services which might fall within the meaning of a package, it seems to me that actually the cruise company would be in the frame for that, because it looks like either a package or a linked travel arrangement of which the cruise provides the other component. And it's not, of course, governed by the Athens Convention, which has a similarly exclusive regime as the Montreal Convention does. So I think the cruise company would be in difficulties with that, but depending on precisely what was said and by whom. But I think there'd be, unlike in the 92 regulations, there would be sufficient, I think, scope for an argument that they should be liable there. Right, and this does bring me on, as Tom did, to fairness of contractual terms. Where you are trying to found an action or defend an action on the basis of contractual terms, you always need to give consideration to whether or not the terms and conditions that you're looking at are actually fair. This is governed by Part 2 of the Consumer Rights Act 2015, which, as Tom rightly says, codified effectively the law on supply of goods and services. It doesn't repeal the previous act. So you've got this sort of these three parallel acts going on together. But the Consumer Rights Act also has this Part 2, which deals with the fairness or otherwise of contractual terms. So some terms are definitely unfair, other terms are fair, and other terms may be fair. And of course, we usually find ourselves in that grey area. But Section 64 of the Act excludes from consideration of fairness terms which specify the main subject matter of the contract, as long as those terms are brought to the attention of the consumer. So things like, what am I actually going to supply you with? It's a package, it's in Jamaica, it involves a 5-star hotel, for example, might be said to be the main subject matter of the contract. But that needs to be brought to the attention of the consumer. And if it is, the consumer can't then come back and say, well, actually, that's an unfair term. Things like price, obviously, are going to fall within that category, as long as it's brought to the attention of the consumer, which has to be done in a transparent way. And transparency is really, the Act is really big on transparency. And again, because it comes from this EU consumer protection sort of hinterland. So you can't look at the fairness of the main subject matter. But the corollary of that is that the provider of goods and services can't attempt to limit or exclude liability for death or personal injury resulting from their negligence. And you see that still with foreign suppliers. Quite often you get people supplying jet skis, people supplying skidoos, husky rides, activities which are inherently risky. You still see European and other suppliers asking holidaymakers to sign waivers that if they die as a result of the negligence of the supplier, that it's a waiver of liability. That does not work. It doesn't work in England, and it doesn't work in Europe either, because all of this is European legislation underpinning this. So those types of waivers are not going to work. They're not going to exclude liability for the supplier, and they're not going to exclude liability for the tour operator either. So you can't rely on them if you're acting for a defendant in that type of case. It's automatically unfair. Now, Schedule 2 to the Act is a non-exhaustive list of terms which might be unfair. So it doesn't say this, but there's almost a presumption that if you come within a Schedule 2 type term, that the court is going to look really carefully at whether that looks like it's fair or not. And there's a number of terms in Schedule 2 which are relevant to us in our situation. There's a number that aren't. And it's all about imbalance. That's what it's about. It's all aimed at not allowing tour operators to impose liabilities on consumers that they don't have themselves. So, for example, things like cancellation rights have to be balanced. The first one of those, it seems to me, is pretty otiose, actually. The object or effect of excluding or limiting the trader's liability in the event of death or personal liability of the consumer resulting from an act or omission of the trader. Now, that's almost otiose, given what we've just been looking at, the non-waiver one. But the difference there, it seems to me, is that Section 65 is talking about exclusion of liability for death or personal injury resulting from negligence, whereas the first part of Schedule 2 is talking about death or personal injury resulting from an act or omission of the trader. It doesn't have to be negligent. So where you've got a term by which the trader tries to exclude death or personal injury resulting from non-negligent acts or omissions, that may or may not be unfair. It is unfair if the term relates to negligent acts and omissions. It may or may not be unfair if it's just something that happens as a result of an actual omission of the trader, which I think is quite interesting. A term which has the object or effect of inappropriately excluding or limiting the legal rights of the consumer in the event of total or partial non-performance or inadequate performance. That's not going to work by reference to the regulations anyway, because regulation 15.2, don't forget, we've just been looking at that, imposes that liability. So any term which tends to go against 15.2 is going to be unfair, both as a result of the operation of the travel regulations, but also as a result of the operation of the Act. Further terms which might be unfair, I'll just take you through them really quickly, and we'll get on to suppliers in a minute. Now, these are all about the consumer handing over money and the trader not giving them something effectively. So where the trader cancels the contract and they've had money, they need to give it back. And other cancellation terms, which is why you see in, for example, ABTA's standard terms, which have been adopted by most of the tour operators and have to be adopted by ABTA members, you see a equivalence between the cancellation rights of the consumer and the supplier. And the reason for that are these terms, which might be regarded as being unfair. There has to be equivalence between, if the consumer gives you money, you have to give them something for it. If you don't give them something for it, you've got to give the money back. You can't impose onerous cancellation punitive rates on the consumer without also having to pay those rates yourself. So there's got to be a balance in the standard terms of the contract. And if there isn't, they're going to be unfair. So effectively, this is another one of the terms which is unfair, but for our purposes, it's pretty similar. It's cancellation term. A term which has the object or effect of binding consumer to terms they've got no real opportunity of becoming acquainted with. So where, for example, you have got a telephone booking and the terms and conditions only come out after that booking, any of those terms are potentially going to be unfair if the defendant wants to rely on them, because the contract was concluded when they made the booking over the phone, and it's certainly arguable that consumers had no real opportunity of becoming acquainted with those terms before concluding that contract. So telephone bookings have always been and remain a real problem for defendants, because if the consumer hasn't had an opportunity of becoming acquainted with those terms, they're not going to bind them, whatever it is that they say. And some of them may attempt to exclude liability or limit liability in certain circumstances. So that's a really important feature of Schedule 2. Term which has the object or effect of enabling the trader to alter the terms of the contract unilaterally without a valid reason. Now, of course, this overlaps quite a lot with the package travel regulations as well, because this is the sort of Schedule 1 type information, which then can't be altered without a valid reason specified in the contract. A term which has the object and effect of permitting the trader to determine the characteristics of the subject matter of the contract after the consumer has become bound by it. Now, that I wonder whether that is going to impact on things like being able to alter flight destinations, being able to alter hotels. That's something that I haven't seen argued properly. It's sort of half been argued in cases I've been involved with, but where I've been acting for the defendant. But actually, there is some arguments that a term may be unfair if the tour operator is able to change hotels, for example, which happens quite a lot, without some good reason, and without the consumer having been informed that the tour operator has that right. So that's potentially a problematic one for defendants. The first of these on this slide is a very similar one. A term which has the object or effect of limiting the trader's obligation to respect commitments undertaken by agents. That's going to come into play where you've got the type of situation that Tom was talking about earlier, where you've got a representation made by the agent, and the tour operator says, oh, wait, hang on a minute, no, we don't, these are sort of special request type situations where the agent has guaranteed that that special request is going to be complied with. You can't then turn around and say, well, I know they're acting as my agent for some purposes, but not for that one, because that looks as if it's going to be unfair and may, under Schedule 2, be unfair. And then a term which has the object or effect of allowing the trader to transfer the trader's rights and obligations under the contract. where this may reduce the guarantees for the consumer without the consumer's agreement. Now, we looked at this when we were looking at co-sharing with airlines. So where, for example, airlines are able to transfer the obligation for carrying passengers to another airline, and where that might reduce their rights and obligations under the contract. So, for example, where I have specifically booked with a particular airline because I like their service, or because I think there's going to be more legroom, you sometimes get with clients. And where that airline then co-shares with another airline, and a different airline then provides the flights, and that means that I don't get the service I want, or it means that I don't get the legroom I want, that may then mean that that is an unfair contract term unless the consumer has previously agreed to co-sharing. And actually, most airline terms and conditions do not refer to co-sharing at all. I think we found one that did refer to co-sharing, and that said, the consumer agrees to the airline co-sharing with other airlines, and that may mean that the consumer's rights are reduced, and there's an actual specific, transparent, explicit agreement from the consumer in those terms and conditions that if the airline co-shares, that they agree to the potential reduction for levels of service or levels of legroom, for example. We saw one airline that did that. In relation to all the other airlines we looked at, they didn't refer to co-sharing. And so it seems to me that if they were then to say to a consumer, well, okay, you didn't get your legroom, but that's because we were co-sharing, that would then potentially be an unfair defence to such a claim. So quite interesting. It doesn't really apply to the package travel regulations because you can't reduce the trader's rights and obligations. They're lumbered with them under Regulation 15.2. And then lastly, a term which has the object or effect of excluding or hindering the consumer's right to take legal action. This is interesting. Some years ago, I was asked to advise in relation to this particular provision because I think it was a tour operator wanted to include in its standards terms and conditions a clause which said that consumers had to arbitrate rather than bringing their proceedings through the courts. And that was under the old 1992 regs, but there's no difference in this regard. That, I think, is problematic. It clearly may be unfair under Schedule 2 because it requires the consumer to take disputes exclusively to arbitration. And it may also unduly restrict the evidence depending on the type of arbitration you're talking about. It only may be unfair. It's not necessarily unfair if the entity, if the tour operator or the airline in question can show why they're asking the consumer to take disputes to arbitration. And if there's a good reason for it, it may well be that a court would say, well, actually, that's not unfair, particularly given how keen the courts are on arbitration now, or on mediation or ADR of some kind. So it only may be unfair, but it's probably unwise to, well, there's no harm in having it in your terms and conditions, because the only thing that's going to happen if a court finds that it's unfair is that that part of the terms and conditions is struck out, and it'll encourage consumers to arbitrate. But it's dubious whether you can force them to do it in quite that way. William's asking, any idea what a good reason for arbitration might be? Yeah, I think, it's, with the courts being so keen on arbitration now, I think you would argue, first of all, it saves time. It's quicker to arbitrate. Secondly, it saves money. It's cheaper to arbitrate. Thirdly, it helps in the administration of justice because it keeps these small claims, for example, out of the court system. Fourthly, there is an interest in not allowing claims farming. So if you've got an airline, for example, with denied boarding regulation claims or cancellation claims, the airline might say, well, there's an interest in us arbitrating with the consumer because legal costs are not going to be payable under that, and that discourages claims farming. And claims farming is bad for everyone because consumers have to pay a slice of their damages to the claims farmers, and it costs us more. So I think you could create quite an argument to say that it's best to go to arbitration than it is to go to litigation. And the courts might well be sympathetic to that, but you would have to show evidence that there was some, almost a public interest in doing that, but certainly a legitimate interest of the trader in question of doing that. So there would have to be, that would need to be evidenced. Right. On to supplier contracts. Commonly encountered in issues. Now, this has got better in recent times, but we used to see really big tour operators, the biggest, wouldn't put the parties to the supply contract, wouldn't input that into the standard terms. So you didn't know who to sue. Or, for example, it was there was just an individual's signature, but it wasn't clear how that individual was acting. Were they acting on their own part, or were they acting on behalf of some limited company or equivalent? So you need to make sure that the parties to the supply contract are inputted. It sounds really obvious, but I've had a number of problems with that. You want your supply contracts to have jurisdiction clauses in them, and you want those jurisdiction clauses to nominate England and Wales as having exclusive jurisdiction. And you want them to have choice of law clauses, preferably nominating law of England and Wales as being the applicable law. And the reason for that is that you want your right against the supplier to coincide completely with the consumer's right against you if you're a package operator. So you don't want a situation where there are two different parallel laws going on, because if, for example, you might have a situation where there's a supply contract that says, well, we've got the same claim that a consumer would have against the supplier, but it's silent as to the law. You might get a different quantum, because English law might give the consumer higher quantum, and Spanish, for example, law might give the consumer lower quantum, although it might be better for them in terms of liability. But the absolute gold standard, of course, is having an indemnity clause in the supply contract. And it's amazing that there are still supply contracts out there that don't have indemnity clauses. But what you want is really tightly drafted indemnity clause, which allows you to recover in respect of claims made against you in relation to the services or goods being supplied by the supplier. And it's an indemnity which covers the entirety of the claim made against you, including costs, including the claimant's costs, and including your costs. Again, it's amazing how many supply contracts there are out there that don't have indemnity clauses, and it's also amazing how many supply contracts are out there that do have indemnity clauses that don't do that job. I think the reason for that historically is that supply contracts were not drafted by litigators, and there's not a lot of point having an indemnity clause that hasn't been drafted or at least looked at by a litigator, because we have different skills to the people who see standard terms and conditions further up the food chain. So we can, I can tell you, looking at an indemnity clause that doesn't mention costs, that you're going to have an issue recovering costs. You also want an indemnity clause that refers to attempts to mitigate loss. So, for example, you want a clause that is going to cover settlements as opposed to just litigation, because sometimes you'll get suppliers who say, well, you shouldn't have settled that claim because you would have won it. And if you've got a clause that covers reasonable settlement, or settlement on the advice of an independent barrister or something of that nature, then you're going to be able to recover, but otherwise there's going to be an argument. And what you're avoiding with supply contracts is an argument. You might win it, but you don't even want there to be an argument that gets there. So drafting indemnity clauses is so important when it comes to enforcing supply contracts against suppliers. So bringing a recovery claim against a supplier, you need to take a decision on whether or not to bring the claim within existing proceedings, so the proceedings made by the consumer against the tour operator, or whether to bring an additional claim. And there are pros and cons. So in relation to bringing them within the main proceedings, that is going to work where you don't think you've got a defence, because it means that you just get the third-party supplier in and they take over the claim effectively, or that is what is supposed to happen. If you do have a defence to the claim and you bring in that additional party, by operation of quoques, you're in a real problem, because it means that if the claim fails against you, you don't get your costs back against the claimant, but because the claim's failed against you, your claim then will fail against the supplier, and you will have to pay their costs because your claim is not a personal injury claim and it's not covered by quoques. So It's almost a bad result if you're a tour operator defendant in a case that involves an additional claim, for you to win, because what you want to do if you brought in an additional claimant is to lose against the claimant and then bring your claim against the additional claimant. So if you think you've got a strong case on liability defending a claim, you don't bring in a Part 20 defendant, you wait and see. If you think you've got a weak claim, you do bring in the Part 20 defendant. And of course, that has its own advantages, because it means that they're going to give you disclosure, they're going to give you witness statements, they're going to be more cooperative if they're brought in. In relation to service, you need permission to serve outside the jurisdiction. And in order to get that permission, you need to establish jurisdiction over the claim. It's going to be relatively easy if there's an underlying main claim, but you don't even have to go through a thought process in relation to that if you're bringing additional claims. So again, there are logistical reasons why it's better to bring in an additional claim at that point. You need to identify the governing law. Again, it's surprising how often even judges don't get that the main claim brought by the consumer against the tour operator can be governed by English law, and will be if it's package. And then the claim brought by the tour operator against the supplier can then be governed by a different governing law. That's not going to happen if you've taken my advice in relation to supply contracts, because your governing law of the supply contract is going to be English. But if you don't have a governing law clause in your supply contract, you've got quite a complicated situation where the main claim is governed by English law and the recovery claim is then governed by some other law, which then needs to be pleaded and proven, and can give rise to a gap between what you recover from the supplier and what the consumer recovers from you. So it just illustrates that you really need to put the governing law into the contract. Are you relying on indemnity? If you are, it makes jurisdiction easier. It means the courts of England and Wales are effectively going to take jurisdiction over the claim, and it makes proving liability so much easier. And as I say, can impact on quantum as well if you've got the right indemnity clause. And then lastly, in relation to recovery claims against suppliers, there is the thorny issue of enforcement. There is some light at the end of the tunnel on that. Tom was saying to me the other day that the EU have now joined the Hague Convention, which does help on that, but we're not signatories to it yet. So we need to sign up to that too. There's no sign of us joining Lugano anytime soon before anyone asks. And I think Lugano is just a pipe dream for the next few years, but it may be that Hague provides a workaround in relation to that. So enforcement, and actually increasingly outside Europe, we're seeing moves towards allowing enforcement of English judgments. It's quite interesting. I don't know whether that's a reaction to Brexit or whether that's just something that's happening. But we've got a Chinese case on at the moment, Tom and I, and it looks as if the Chinese are moving more towards enforcing English judgments. So that's, perhaps hopeful, because that was a jurisdiction which I thought would be difficult. Right, that's a quick canter through all of the contractual stuff that you may need to know in relation to either package or airlines or recovery actions. Any questions? I think we answered them as we went through, but if there are any questions left, have we come in under the hour? No, I'm 3 minutes over the hour. Still happy to take a couple of questions if you would like. Otherwise, thank you very much for bearing with us. It's quite a lot to get into one webinar, but I think it helps to see it all in one go, because it's actually quite it's quite interlinked, particularly the airline stuff, although the recovery stuff is perhaps different and you need to think about it in a conceptually different way. Right, no questions?
Just a quick apology from me. I see from the chat that there might have been some connection issues from me earlier on, so I do apologize for that. I hope everything's been picked up by the recording, but if it hasn't been, and then actually it's a problem that there's a problem in the recording as well, then do feel free you've got my email address there, do feel free to email me about anything that might have been missed, that I can usefully help out with. Maybe, I don't know, maybe there'll be something we can do with the recording, re-record some bits if any bits were lost along the way. I do apologise for that. Oh, and the other
I got all the Eurovian bits actually, so I was fine.
Right. Okay. Well, that's good. The only other thing to say is, I think there was a question about or a comment about consumer law and EU consumer protection and all that kind of stuff. I wasn't intending to make any kind of pro or anti Brexit comment. I was just saying essentially that the EU position, EU law is very different from traditional English law in that kind of contractual position. And so the effect of having incorporated EU law on top of the English common law position has created a little bit of a mess and a muddle, and it's not quite as simple as the kind of classic English contractual law position. But I wasn't intending to comment on that it was a good thing or a bad thing, really. Just that's the way it currently works.
Yeah, no, absolutely. I held you to be quite neutral, Tom, quite carefully neutral.
I'm a former civil servant, so that's my way.
That's your default position.
Yeah.
True. So Anne has said, unfortunately, I'm finding the more robust the indemnity, the less likely it be accepted by the supplier. I mean, yeah, I appreciate that. And actually, suppliers have kind of got wise to that now, that, you know, some of these indemnities are pretty watertight, and you get pushback. But it depends. I mean, a lot is going to depend on the bargaining positions of the two parties, isn't it? If you're a big tour operator, your bargaining position is not unfavourable, and possibly COVID has made the bargaining positions of the respective parties different to what they would otherwise have been. But I do take that point. The problem is that if you don't have a robust indemnity, it does create difficulties, particularly with settlements as opposed to court awards. And of course, some suppliers are saying that they won't indemnify anywhere until there's a court judgment, which creates a situation where the defendant has to go through the motions of defending the claim, even when they know they're going to lose. But that is not, in a service industry, a great look. It has to be said, but there's not actually very much that tour operators can do about that, because of the operation of the package travel regulations, which just impose this liability in the way that Tom's been talking about. Right, well, if there aren't any other questions, I will draw the webinar to an end. Thank you all very much for coming. Thank you for your perceptive questions, and for bearing with us as we cantered through the unfair terms. But do give us a shout if you have anything that occurs to you afterwards. Thanks all, and have a lovely day. See you soon, Tom.
Thank you. Bye.